There are several ways to repair an automobile damaged in an accident. Not all of them may be correct or lawful. I'll talk with consumer protection experts right now on The Law Works.
From West Virginia Public Broadcasting.
Closed captioning for The Law Works is made possible by a grant from the Monongalia County Bar Association to support legal information and education for all West Virginians. The Law Works is made possible by a major grant from the West Virginia Bar Foundation, the philanthropic organization for West Virginia's legal profession and legal system, promoting public knowledge of the law in West Virginia. By the generous support of Software Systems Incorporated, a West Virginia company established in 1975, providing high-end support services, programming, and consulting for county government AS400 mid-range computer systems, as well as PC-based systems. And by viewers like you.
West Virginia has adopted very specific laws concerning the repair of automobiles after an accident. My guests are Deputy West Virginia Attorney General Jill L. Miles and Assistant Attorney General Matthew Stonestreet. Jill, Matthew, thank you for joining us. And Jill, welcome back. You've been here a number of times before.
Thank you, Dan. I appreciate you having me back.
But you work in an area that we're particularly interested in here at the Law Works, and that's consumer protection.
Right.
And Matthew, you're in that same division in the Attorney General's office.
Yes, sir.
We're talking about automobile repair and junkyard parts. Now, you've got your pencil out ready to write a letter. We talk about junkyard parts. Some people call them recycled parts, some call them repurposed parts, some call them used parts. But the fact is, the parts we're talking about in this program, used in automobile repair, typically come off of cars that have been damaged, abandoned, salvaged, or, quote, recycled. It's all the same thing for our purposes, so you'll excuse us if we seem politically incorrect to you. Why are these parts junkyard? Why is this an issue?
Okay, what happened, Dan, is basically in the late 1980s, you had a lot of companies, typically from Asia, were creating parts that were being put on cars like Ford, Chevys, Hondas, whatever. And they weren't parts that were being made by the original manufacturer. These parts during that period of time were of inferior quality. So, and they cost a lot less. So your car was in an accident, your insurance company would pay for a part which is called an aftermarket crash part, put that part on your car. You know, body shops hated them. They didn't fit, the quality wasn't the same, they were inferior. So legislatures started passing statutes that said you cannot use aftermarket crash parts on vehicles less than 3 years old. That was in 1988 when West Virginia passed their statute. So in the meantime, insurance companies said, okay, well, we can't use these aftermarket crash parts, but what we'll do is we'll start going and getting parts off of cars that have been declared salvage, and we'll use those parts on your new car.
Now, a car that's declared salvage, that means the car is totaled,
right,
and we're going to take the usable parts off of them and sell them.
Right. So you have a car, you're in an accident, it would cost more to repair the vehicle than the vehicle's worth. The insurance company calls it a declared loss, and then what will happen is they'll take parts that have not been involved in the accident and use them to repair new vehicles. Well, this issue came up in about 1997, and it was our position that that violated this aftermarket crash part statute. That statute says that you cannot use, that you have to use genuine crash parts that are sufficient to maintain the manufacturer's warranty. So manufacturers, Ford, Chevy, were telling us, look, we're not going to warrant a part that's been sitting out in a salvage yard. And that made perfect sense to us. That case went to litigation in 1998, and the Kanawha County Circuit Court ruled that you couldn't use used parts, salvage parts, reconditioned parts, whatever you want to call them. Fast forward to 2011, okay, 13 years later, whatever. We get word that one insurance company, Liberty Mutual Insurance Company, was requiring their body shops to use salvage parts on vehicles less than 3 years old. So here we are today.
And we have a statute that says you can't use those parts during the year of manufacture of the car or for 2 years after that.
Right.
Hence 3 years.
So let's take this year, it's 2012. So if you have a 2012, a 2011, or a 2010 model vehicle, it would be our position that if your vehicle is in an accident and you have to repair a part, and these are crash parts, so when we're talking about things like fenders, quarter panels, hoods, tailgate assemblies, you know, the sort of the outside of the car, if that part has to be replaced, it's the position of the West Virginia Attorney General's office that that has to be repaired, or the consumer has to consent to something different with a new original equipment manufacturer part.
So if you're going to use a used part, let's just use that label, you have to tell the consumer that's what you're going to use, and the consumer has to say it's okay with me.
Yeah, that's right. They have to disclose it, and they have to get the written consent of the consumer. And of course, people who have brand new vehicles aren't going to sign a consent that says it's totally fine with me if you use this 7-year-old, less safe, inferior product in the repair of my vehicle.
Ah, that's easy to say, but as one who has had a car repaired from time to time, what you get is an estimate from the body shop. You take it in, say, my insurance company said to come see you, you would estimate this car preparatory to having it repaired. And you get a form that fills out all the parts and all the costs and the labor charges. And at the bottom, they say, here, this is your estimate, sign this is to acknowledge you received it. And in that real fine print at the bottom says something akin to, and I consent to the use of aftermarket used salvage parts.
Well, thankfully, the statute says it has to be in all caps, it has to be a certain size, it has to be right where they're signing. They made sure that this wasn't something that you could just slip in and people would sign. Of course, you know, they still might figure out some way to do it, but the statute did a pretty good job of.
Presuming the customer reads what's at the bottom.
Well, in this situation, you have to sign it. So
you don't have to read it, Jill.
Well, that's
which incidentally is why we're doing this program. Read these things. Don't sign something without reading it, because you might be surprised at what you find in there, even if it's in the largest font in that part of the page and it's in all caps. Sometimes we just don't read these things, and you need to do that, and you need to think about the ramifications of what you're reading. So let me ask you, why are you concerned about somebody using a perfectly fine part, objectively, off a 3-year-old car that came from a different part of the car that was damaged in the collision that ruined it? Why can't I use the right rear fender off a car that was hit in the front left?
I mean, yeah, that's a fair question. And the truth is, we don't know what's happened in this part, where it's been, what the environmental exposure is. And in some clinical research that they've done on this, they found that a used part, when it gets into an accident, can suffer from 40% more damage. And of course, you know, that affects the people in the vehicle. Having 40% more damage happen to a bumper or a fender or a radiator. They aren't subjected to the same regulations that manufacturers are when they get their crash test ratings, when they test their bumpers and fenders and things of that nature. They're basically just taken off of a used car that they don't know where it's been, how it's been repaired, and slapping it on another car.
Well, and in point of fact, modern cars are designed to absorb the energy of impacts and to transmit it through the body of the car, not through the passengers in the car. Right. And I've seen cases where people would own older cars. They say, my car's indestructible. I got hit in the front, put a little dent in the bumper, and the rest of the car is absolutely fine. And how you feeling? Say, oh, my neck's killing me. Well, the reason their neck's killing them is because the energy of the accident was dissipated in their neck, not in the body of their car. And the Highway Traffic Safety Commission wants the car to absorb the impact, not the people in the car.
Right.
So you don't know. The right rear fender may be where all that energy went.
Exactly.
Also, when a car is stored after an accident, if it's been totaled, typically it's stored outside.
Right.
And you have all kinds of weather issues.
You know, another issue that Matt didn't mention, but I think is important, is one of the most common parts that they use is the bumper. So they take the bumper off the car, and let's say the car was blue. It goes to the repair shop. The repair shop does a little bit of priming, but they don't take off all the blue color off the bumper. And your car is green. So they paint over the blue bumper, put it onto your car, and every time you're parking and you nick it, it chips away easier because it's paint on paint instead of paint on metal. And so within a very short period of time, you're able to see the color of the original bumper. So you're not getting the same quality part. And I think it's also important to mention, Dan, this statute doesn't go back forever. It's just talking about basically brand new cars. And when you buy a car, I just bought a brand new car. It cost me $28,000. If I was in an accident when I leave this studio and they wanted to put a used part on my car, I would have some issues with that. Because I'm not getting something, first of all, it wouldn't be warranted. There's no question that the manufacturer's not going to warrant that part. There's a big argument as to whether or not the manufacturer is going to warrant any part that part touches, especially if there's a problem. And you just don't have what you had pre-accident. So we don't think it's fair. The legislature didn't think it was fair. And now we're in a battle with Liberty Mutual because they want to save money.
We're talking about automobile repairs and junkyard parts. My guests are Deputy West Virginia Attorney General Jill L. Miles and Assistant Attorney General Matthew Stonestreet. I'm Dan Ringer, and this is The Law Works. One of the underpinnings of American civil law is that if you are harmed through the actions, inactions, or fault of another person, the court system, the justice system, is designed to restore you to the condition you were in before the harm occurred. And when we say you, we mean you, your property, your situation. So if you have a 1 to 3 year old car that is damaged, the justice system wants you to have a 1 to 3 year old car in the same condition after the process is over.
Right.
So if you've got a car that doesn't have parts covered by warranty, you're not in the same condition. Have you been down this street before?
Right. I mean, as I mentioned earlier in the show, this same exact issue came up in 1997. And we were actually sued. The Attorney General's office was sued because we took the position that they couldn't put used parts, that this statute applied to both aftermarket crash parts and to salvage junkyard parts. And State Farm and the Automotive Dismantlers Recyclers Association sued us in the Circuit Court of Kanawha County. It went before the Honorable Charles King. He heard the issue and he said, wait a minute, guys. The statute says that it has to be a genuine crash part, in other words, the original equipment manufacturer part, and it has to be sufficient to maintain the manufacturer's warranty. And this part that's been sitting outside off a damaged vehicle has no warranty. And that's not fair. What was interesting is that then we come to 2011, and you're right, Dan, and I think this is a very important point. I think this has been going on, but we didn't know it was going on because people don't know that the used parts are being put on their cars. The way we found out about this is a body shop contacted us. And Liberty Mutual had basically said to this body shop, Joey Holland's Body Shop in Charleston, West Virginia, hey boys, you need to start putting used parts on these new cars. And if you don't put used parts on these new cars, you're not going to be a preferred body shop anymore. And Joey Holland said, hey, that's against the law.
Now, preferred body shop means that the company would recommend them to repair cars that their insureds had damaged.
Right. These are body shops that the insurance company has established a relationship with. They trust them. And because they trust them, they will go ahead and let the body shop itself do the original estimate, so you wouldn't have an insurance adjuster doing it. The body shop gets business. You know, it's much easier for the consumer. The body shop gets a lot more business from that insurance company, and the body shop in turn provides the insurance company with the discount, really is what happens. So Joey Holland was a preferred body shop or a total Liberty Care facility for Liberty Mutual Insurance. And when they found out that they were not putting used parts on new cars, they called them up and said, you have to do this. This is our new policy. And Joey Holland said, no way, I'm not doing that. And by the way, here's Judge King's order from 11 years ago. And they said, well, you know what? We don't read it the same way Judge King does, so you can't be a preferred body shop anymore. They contacted us. You know, I worked on the original case. We contacted Liberty Mutual, and they didn't want to cooperate. They felt that our statute was preempted by federal law and that they could use used parts, and right now we're in litigation.
Okay. Preempted by federal law.
Right.
What does that mean?
Go for it, Matt.
25 words or less.
Their legal theory is there's the Magnus-Moss Warranty Act, this federal law that says manufacturers cannot take away an entire car warranty just because of the use or repair using an aftermarket or used part. Now, somehow, logically, they take this leap and say, well, since the manufacturer can't just claim an entire car warranty, that means we don't have to follow your state crash parts law because they basically have the same warranty they would have had anyway, and now we don't have to follow your law. So that's, I mean, that's the theory. And
well, but the part isn't warranted.
Yeah, well, that's what we said in our response to their motion to dismiss. So yeah, that's exactly what we said. Right. It's not warranted. And, you know, I think, and she could speak to this better than I could, but when you have a case like this, where, I mean, they're basically dead to rights on the facts. We know that they're repairing all of these vehicles with used parts. We know that they're not telling any consumers. They're not even putting the fine print in there and telling them. They're totally keeping this from them. You might run into some more desperate legal arguments saying, well, sure, we might have violated your law, but we don't really have to follow it. And I don't think that's too uncommon. We'll run into preemption arguments.
We're talking about automobile repairs and junkyard parts. My guests are Deputy West Virginia Attorney General Jill L. Miles and Assistant Attorney General Matthew Stonestreet. I'm Dan Ringer, and this is The Law Works. Well, when we talk about federal preemption, the concept of federal preemption is that if there's a federal law governing an area of law, the federal law controls, and the states really don't have anything to say about it. The Magnus-Moss Warranty Act doesn't exactly say that, though, does it? No,
it doesn't conflict. There's no express preemption in this case. And as we pointed out for the federal judge in this case, these laws exist harmoniously. The Magnus-Moss Act, the West Virginia Consumer Credit and Protection Act, and our Auto Crash Parts Act all exist working together to protect the consumer. We're protecting them from having lower quality parts placed onto their vehicles. The Magnus-Moss Act is protecting them from having their entire car warranty taken away from the manufacturer. And in no way is there a conflict to where we can't work together to protect the consumer with these laws. There's really no preemption here at all. And you know, like I was saying earlier, I think it's just sort of a desperate legal argument they're having to make because we know they're putting these parts on cars, and we know they're not in compliance with our state law, so what they have to come up with is, well, we don't have to follow that law.
Right. The Magnus-Moss Act, basically, anytime a state statute provides greater protections for consumers, the federal law says that state statute is okay.
So it doesn't preempt entirely
Absolutely
that area
not.
of law?
No.
It says you can pass laws that are more strict than federal laws, but you can't pass laws that are less strict.
And that's what the Magnus-Moss Act says in particular.
Right.
It specifically says that.
Here's the reality of what's happening, Dan, and this is something that happens to us all the time, is if you remove the state to federal court, it's an automatic removal, and it buys you time as the defendant. That's my position on that. I think it's a legal maneuver. So you get into federal court, they buy themselves another 2 months. I'm hoping, I believe, we'll be remanded to state court, and we'll move forward with our lawsuit.
So this is a matter that is not ready to be resolved by a judge and jury.
Right.
Nor does it appear to be ready to be resolved through compromise negotiations.
No. I mean, at one point I thought that we had reached an agreement, a settlement, because as Matt said, we agree. I mean, they are not denying that they're putting used parts on new cars. That is not at issue at all. The issue is whether or not this federal law prevents the state attorney general's office from enforcing state law.
Now, is there any question that the automobile manufacturers will not extend their warranty to cover these parts, these aftermarket parts?
Well, with the use, they absolutely will not warrant used parts that have been, the warranty is voided and they will not warrant, and it makes sense. Would you want to warrant a part that has been sitting outside in the elements and you have absolutely no control of where it's been or what's been done to it? I mean, I think that that's a fair position for the manufacturers to take.
As a judge might say, that's your argument, counsel.
Right.
It is important to recognize that this is a case that is currently in litigation. There are at least two sides to it. One side saying one thing, the other side saying the other thing. And in the fullness of time, one would expect a judge or a jury in an appropriate case to make a decision. What we're talking about today is the Attorney General's position, Attorney General Del McGraw of West Virginia, and his office, your position with regard to this information. Now, as I understand it, Ford, General Motors, Toyota, Kia, Hyundai is saying, no, those aren't our parts. We're not going to warrant those parts. And by the way, if those parts mess up something else, we're not going to warrant that either.
We've attached the position statements of these manufacturers to our pleadings in this case, and they either say we don't warrant or we don't support the use of these because we don't think they're safe and they've been out of our realm of control and out of our domain. So that's something that the judge will consider when they look at it, but they'll know right away, not just because of your very good argument, but because the manufacturer's position statements are going to be right there saying, look, this isn't something that we warrant, this isn't a policy that we support.
But at the same time, the insurance company comes back and says, well, if Ford, General Motors, et cetera, isn't going to warrant our part, we'll warrant it. So doesn't the consumer end up having the same warranty that she had before the accident?
It's actually an illusory warranty. It's a warranty that's non-transferable. If this person sells the car to someone else or trades it back in, the part has completely lost its entire warranty. And on top of that, there are different nonprofit groups and other people that say, look, when this part does fall apart, even if you do try to redeem that individual warranty that they're giving you, there are difficulties even with that. So it's definitely lost when it's transferred because it's a non-transferable warranty. But then there are even questions on redeeming that warranty when something does fall apart.
Well, I guess we'll see where this goes. One of the wonders of the court system is there's always another pleading to file. There's always another hearing to have. So stay tuned, folks, and we hope to be able to bring you an update on this. Now, recently, Jill, with regard to the Consumer Protection Division of the Attorney General's office, we did a program concerning the mortgage crisis and a settlement that the Attorney General and the National Association of Attorneys General reached with a number of banks. There have been some scam activity with regard to getting information about that. Can you tell us what that is?
Yeah, just recently, I think even yesterday, we were getting reports of people calling people up, telling them that they could help them get money from the settlement, but that they had to give them $500 and their bank routing number. So once you give the crook your routing number to your checking account, they have access to your checking account and can basically drain it. So that is the most recent scam that we've heard about with respect to the mortgage relief problem.
If you get an email or a phone call offering to sell you information about the mortgage crisis settlement that we talked about recently and that we're referring to here, you do not have to buy that information. You do not need to hire anyone to see if you're eligible for it. Call the West Virginia Attorney General's hotline at 1-800-368-8808. 1-800-368-8808, and simply ask for information. They'll send you the forms that you need to apply for relief under the Mortgage Settlement Act. They will answer your questions. They'll help you determine if you are eligible. Or if you would like to go online to the Attorney General's website, it's WVAGO, West Virginia Attorney General's Office, WVAGO.gov, and you can download forms and get other information there. Jill Miles, Matthew Sonestreet, thank you very much for joining us.
Thank you.
Thank you, Dan.
Thank you also for joining us. On behalf of the Law Works, I'm Dan Ringer. Good evening. On the LawWorks website at thelawworks.org, you'll find a listing of recent The LawWorks programs, additional information about this show's topic, and video of this and recent shows. You can also find the LawWorks programs on YouTube and iTunes. If you would like to suggest a topic for a future The LawWorks show, or if you're a school teacher and would like to receive a DVD of this show for classroom use, send us email at thelawworks@comcast.net or visit us on Facebook.
The LawWorks is produced in cooperation with the West Virginia Bar Foundation, the Mountain State Bar, the Monongalia County Bar Association, and the West Virginia University College of Law. The LawWorks is made possible by a major grant from the West Virginia Bar Foundation, the philanthropic organization for West Virginia's legal profession and legal system, promoting public knowledge of the law in West Virginia. By the generous support of Software Systems Incorporated, a West Virginia company established in 1975, providing high-end support services, programming, and consulting for county government AS400 mid-range computer systems, as well as PC-based systems. And by viewers like you.
From West Virginia Public Broadcasting.